good morning. Welcome to the first forum of the year. Glad to see a lot of you here today. We have 50 participants, so that's almost every district. I hope everybody's year is starting off probably a little better than last year was starting off, hopefully. We have some great presenters today, so we're going to just go ahead and get started. So on the agenda, can you see the agenda on the screen, April? Thank you. So today we have Kelly Early from Workers' Comp. We'll give a little introduction and a little update on what's going on in Workers' Comp. And then we have Chris Bishop from WKMCB Law to talk about reasonable suspicion in the workplace and some COVID updates as well. Then we have Dawn from CRISC to let us in on everything that's going on in their world, and hopefully to tell us that RDS is back up and running today. And then we will have Russell Rice from Teaching and Learning to give our quick little update from all of the things that our teaching and learning folks are hearing from the ESD, so we're all on the same page. Then we'll talk about updates and reminders, kind of closing out last year and getting started for this year, information sharing, and noteworthy items. And then hopefully we'll have time at the end to do some breakout sessions and let you guys see each other and just kind of get reacquainted. So with that, Kelly, you are on.
Well, thank you, Julie. We sure appreciate you allowing us to tap in. You know, I'm not clear. Every time I do a Zoom, it's a surprise if my photo is going to appear or not. So I apologize. You probably can't see me. I want to do a really quick shout out before Chris takes over. The Trust is already experiencing a surprising number of employees in your school districts who have chosen to retire at the last minute. And it's incredibly high priority important that you partner with the Workers' Comp Trust when somebody is retiring and they have an active workers' comp claim. We've had to resolve some of those issues at the last minute. We have statutes under workers' comp that talk about employability, and those employabilities must be resolved before that person is put before the school board for approval of retirement. So please reach out. I can talk to you in more detail. We're here to actually navigate that on your behalf, and we just need to know about those situations. And so I'm going to turn it over to Chris. I noticed that we have two Chris Bishops in the house today. So Attorney Chris Bishop he's been in practice for 20 years, but he's been our lead counsel for about 6 years. And most, if not all of your school districts have benefited from Chris's work. He makes us a priority. He is an absolute stellar attorney and a great companion to have on our team. And so Chris, I'm going to turn it over to you. Oh, I should also say that about 9 months ago when we reached out to Chris and asked him to do a talk today, that topic was really about navigating drug and alcohol in the workplace and what the employer's responsibility is. And it's only been a few days since I said to Chris, we're getting a lot of questions about COVID, and could you please talk about that as well? So he's found time on the agenda today to talk about both those topics. Chris?
Good morning, everyone, and thank you, Kelly, for those kind words. I'm going to do a screen share now, Julie. Let's see. Okay, I think you guys can see that, all right?
Yep, we can see it, thanks.
All right. Before I just start with my presentation, I just would like to thank Kelly and her team, Mark, Aaron, and Stacia. They're wonderful to work with, and it's been a pleasure getting to know them. They really work hard on behalf of the trust for the schools and their benefit. And to kind of echo Kelly's sentiments regarding retirements, I see that on my end on the legal side, and so I'd echo just her reminder to work with her and her team in those situations where someone has a claim and they're looking to retire. I also wanted to take a few seconds this morning to just thank the ESD, the school districts, all the educators out there. I know this pandemic that we have been in for almost 2 years now, if you believe it, is taxing on everyone, and especially those who are on the front line, like yourselves. And I appreciate the time and sacrifices and resources you've dedicated to educating the children in your areas. I know it's not easy, and I know it's been stressful and hard for many of you. And I just want to thank you. I don't think enough people do that. I just want to thank you for all your hard work to try to make this work for the kids. So as Kelly mentioned, she reached out to me recently to talk about some things regarding reasonable suspicion and drug testing in the workplace, and answer any questions that may come up there. Also, the state legislature has been really busy this past year in addressing the pandemic and the COVID issues that we all face. And so she also asked me to throw some things in there regarding the new bill. So I'd like to start off with just generally what we all know. And I would hope that all of our school districts have a policy in place that advocate for a drug-free workplace. And I wanted to start off with, well, why is this the case? Well, for many years now, both on the federal level and the state level, we've had laws passed by Congress and the state legislature regarding drug-free workplaces. The main one is that we may all know is the Controlled Substances Act here, which prohibits narcotics, etc. Controlled substances, which includes still marijuana on the federal level. And we have federal laws regarding drug-free workplaces if you receive federal grants. We have federal laws concerning CDL, which would apply to bus drivers and those related to bus driving in school districts. We also have state laws here that I've outlined that talk about, drug-free workplaces in schools, the school buses themselves within 1,000 feet of school grounds, bus stops, parks, etc. We also have a state law, RCW 6950-445, that prohibits the opening or the consumption of various marijuana goods. And there's a whole litany of things that the legislature has spelled out there in general public or public place. If you've ever been to a Seattle Seahawks football game or other kind of public place where there's a lot of people, that's probably not enforced, as you can see a lot of consumption, but there is a law in the books about that. So that is the federal and state policy that we're talking about here today. We also have DOSH or OSHA rules that require employers to keep their employees safe under WAC 29680-11025. We have the general DOSH rule that employers are required to keep the workplace safe. This is the go-to rule that DOSH uses when they cite employers for unsafe workplaces when they can't find a specific rule. This rule creates a general duty for all employers to create a workplace free from alcohol, controlled substances, etc. The test here is whether you knew or should have known that employee was under the influence or impaired due to some sort of drug or alcohol related substance. So that's a duty that the state puts on us. So that's why we require testing. We also have federal, let's see. We also have this WAC 35737-200 that allows for us to have drug testing in the workplace. And I want to review that WAC with you here real quick. And I apologize, for some reason my light here went off. Just a second. There we go. We're protecting the lights here. Under WAC 35737-200, employers are able to drug test under certain circumstances. This rule requires a number of things in order for you to do drug or alcohol testing on a state level. The first thing it requires is having a legally compliant drug policy in place. And I would imagine all, if not most of the school districts have some sort of drug and alcohol policy in place. And that's important because that is the policy that you are going to follow as you engage with your employees concerning these issues. Secondly, the law requires that you treat any test results on a confidential basis. Similarly, if you have a workers' compensation claim or other ADA medical issues, you're required as an employer to have a separate folder for those kind of confidential medical documents. And the similar thing would apply here for drug test results. It must be kept confidential. You do not broadcast it to the general public. It's on a need to know basis. Secondly, third, this rule requires that you have specific objective grounds, or otherwise known as reasonable suspicion, to believe work performance is impaired due to the substance. And we'll talk about that in a little more detail here shortly. This law also requires putting reasonable suspicion aside. If you have a policy in place, you can do post-injury or accident drug testing. And that's important for workers' compensation claims because sometimes those things cause accidents or injuries, the use of substances, that is. So if you want to do that, make sure that that is included in your policy because you have the right under this rule to do that. You also, if you have a policy in place, can have drug testing if you want to ensure public safety or if the job requires the use of a firearm or it's safety sensitive. On a federal level, and we talked about this earlier, you have the right to do drug testing for those who have CDLs. In most of your cases, that involves bus drivers. And under this federal law, 49 CFR Part 382, it allows for pre-employment, post-accident, random, reasonable suspicion, return to duty, and follow-up testing. Many of you are probably very familiar with this, and I'm not going to go to each one of these types of testing that you can do as a school district, but just for example, pre-employment, you can't just do anyone. As a public agency, your pre-employment drug testing must be limited to safety sensitive positions. On a federal level, you're allowed to do that for bus drivers and other safety sensitive positions such as mechanics or technicians related to bus driving. Post-accident drug testing on the federal level for bus drivers and those people in those situations is also allowed, just like it is under state law, which I just reviewed. So let's focus more on the reasonable suspicion, okay? So as I've indicated here, under state law, you must have specific objective grounds of impairment. Under federal law, they characterize it as specific, contemporaneous, articulable observations. And so you may ask, well, those are really fancy words. What does that mean? Let's get into some specifics here. So what are considered objective observations or something you can articulate? Well, here are some things that I've delineated for you. Let's just talk about walking. If you see someone stumbling, staggering, swaying, or even falling, for heaven's sakes, then that would lead to reasonable suspicion. Eyes. If you're looking at someone and they're bloodshot, they're glassy, watery, or they look dilated, that could lead to reasonable suspicion. The obvious, breath, if you smell any odors, whether it's alcohol, marijuana related, or some other chemical odor, that could lead to reasonable suspicion. Speech, are they slurring, rambling, slow, whispering, or even very fast and out of control? Those could be reasonable suspicions. Appearance, not just how they're dressed, and if there's a change in kind of their how they dress, where they're really well put together and professional looking, and all of a sudden they start looking disheveled, maybe that could be part of your observation. Obviously, if you're seeing someone with track marks or puncture marks on their arms, that could be a suspicion that's reasonable. And then tremoring. Finally, look at their actions. Are they hostile where they would otherwise be friendly? Are they falling asleep at work? Are they drowsy? Are they expressing beliefs that are paranoid in nature or manic in nature? And then also consider, are they hyperactive where they were normally not hyperactive? These are just some examples of behaviors that one can observe that would be considered to be reasonable. But certainly, I would just caution you that there are other reasons why people could have these things. You know, for example, bloodshot. If you just didn't get any sleep the night before, that could lead to bloodshot eyes. If you're staggering, maybe you're limping or something because you twisted an ankle. So just be careful that we're using reasonable suspicion the right way, and we're not targeting those who could be otherwise disabled or require accommodations in the workplace. Let me see here. I'm going to share. Let's see. Hopefully it'll allow me to do it. Okay. I wanted to share you some examples of some forms that I've seen or used in the past for reasonable suspicion. And if you don't have a form for your school district or something similar, you can reach out to me and I can share these with you. But here are some examples of forms that you might be able to use in documenting reasonable suspicion, because it's important that you document. You know, for example, in this form talks about employee, observation date, the location, time, that sort of thing. And then it has a checklist of different things that you observed or someone informed you about, and then you're documenting. And you can see there's just a litany of things that one can go through here in documenting what is reasonably suspicious. And these are just examples that have been vetted over time that are considered reasonable. And so I just wanted to share this with you as a document that one can use, because you are required to document your observations and not just say, well, I saw Johnny or Susie acting this way. And so this one I found to be pretty extensive on the various physical and behavioral things that one could see or observe in this setting. So in addition to that, they have a form on this form. They have a section about, you know, do you have other witnesses that would have seen this? If so, identify who they are and what they observed, and you can document other observations that may not be on this. And then there's a section as you converse with this employee that you have suspicions about, and you explain to them what you observed or what someone brought to your attention and they observed. They have an opportunity to respond. And then there's an action plan on this section. And then where you go from there. I'll share another one with you that's more kind of check the box form. Again, very similar: name, time, location. What's the suspicion? Is it alcohol, drug, or other related, or both? A bunch of check the box things you could observe in their behavior, in their speech, motor skills, that sort of thing. You know, there's a section on this one. Did the employee admit to using the drugs or alcohol? When? How much of the substance were taken? Again, another section about who witnessed this, what time, and so forth. So it's important that you have the ability to document the suspicions that you're observing and others observing as it's required. The law requires that the person that's making the ultimate documentation be trained in how to gauge someone's behavior. And I would recommend that a second person also be in place if you have the staffing ability to also be trained to make these documents. Create the record of what you observe. Do not do it out of memory, or do not do it through verbal hearsay, but specifically write down what you are observing. Even if you don't have a check the box thing, make sure you document what you are observing, what others are telling you. It's important that this document and observation be done in a very tight time frame, The law requires that it's just before starting work, during work, or just after work. If you're on the weekends and you see Johnny or Susie and you see them impaired or otherwise incapacitated and they're not in their work capacity, that's not sufficient for what we're talking about here. You can't on Monday then all of a sudden drug test them. It must be during, just preceding, or just after work that is the justification for this. Please complete the documentation in a timely manner. The recommendation is within 24 hours. And finally, it's important, and I'm sure this is in place in every school district, that it's a third party that is doing the testing and verification of the impairments. As I kind of wrap up this section of my presentation, I wanted to show you kind of the flow, if you will, of how you could document reasonable suspicion and implement a policy in your workplace, as I kind of outlined before, but I'll just kind of go through it real quickly here. Make sure you have a trained supervisor that's documenting the suspicious behavior. If you have a second supervisor, that's even better for you. The law always likes, testimony from more than two witnesses, two or three witnesses. Make sure that once you've done your documentation, you're arranging for the testing. If they agree to the testing, you go a certain route. If they don't agree to the testing, under federal and state law, there are circumstances where if they refuse to be tested, then that would be considered the same as a positive test. And I believe this is just a very good flow chart on how you can handle these situations. Ultimately, if there is a positive test based upon your reasonable suspicion, then it's up to your local human resources or business office to decide what you are going to do to implement your policy, whether you put the employee through some sort of program that gets them help, or whether it's at the level of termination, so forth. One thing to keep in mind as you're doing this, the law also protects those who have disabilities. Under the law, if you have a drug addiction or have alcoholism or otherwise an addiction to a substance, then you could be seen under the law, under ADA, as a person that is disabled. And so in addition to this flow chart, you may have an additional threshold that you have to go through to make sure that you are accommodating someone who has a documented disability. And it's appropriate to work through the ADA good faith process with that individual and their addiction. And that's why oftentimes you'll see employers put someone through a substance abuse program and work with them as they go through that system. So before I transition on to COVID related issues, just want to see if there's any questions. I'm not monitoring the chat right now, but Julia, I don't know if you see any questions that are applicable to this. I'm seeing how do you log in kind of stuff. So I didn't see any questions there, but I will pause for a couple of seconds to allow people to throw some things in chat, questions or otherwise.
Right, so I'll just offer up, it's Kelly here. It seems on the surface unusual that workers' comp would solicit you to talk or speak on this subject. And it's relevant because we do see this come into play in workers' comp claims. There have been missed opportunities. We've had to pay for some very expensive medical treatment and some very expensive legal fees to defend our school districts once we have found out and been able to demonstrate that, oh, the person actually admitted to their doctor in a medical report months and months later. So storyboards unfold over a period of time, and it's just, there is relevance both in your work site and in your workers' comp exposure.
And I guess to that point, I think it's important that we be proactive in identifying these issues, because and that's why I brought in that first, one of the first slides mentions that rule that we have a duty to keep the workplace safe, not just for that worker, but for other workers. And if we're proactive in keeping our workplace safe and we're making the necessary observations and documenting those observations, it can not only save that worker's life or prevent them from becoming disabled through some sort of injury, but could prevent someone else in the workplace from getting injured as well. And so the ramifications, as Kelly points out, can be significant if you know or should have known that someone had an issue and that you should have addressed that issue. That could lead to some pretty significant costs, both financially and otherwise, to that individual and your coworkers. I'd just like to echo Kelly's sentiments that, yeah, let's be proactive on this so that we can avoid any further harm for those employees themselves and for their coworkers. So, any other questions or comments from the group here? If not, seeing none, let me know, Julie, if I'm missing anything.
I don't see anything in the chat. Thank you.
Okay, great. I will move on to what is potentially the hot button topic here today. So to kind of give you a little bit of a history lesson, like I mentioned earlier, it was February 29, 2020, when Jay Inslee, our governor, declared a state of emergency in relationship to the COVID pandemic. When he did so, he issued a number of orders that he felt were necessary to afford workers' compensation benefits to certain workers in the state of Washington. The state legislature then took that and ran with it and implemented a number of changes this last session. And one of those is the one I'm going to review with you here today, the Substitute Senate Bill 5515. This law became effective May 11 of 2021, so immediately upon passage. So what does this law do? It creates a presumption that has never existed before in the state of Washington. It's presumed that if you have a declared public health emergency, which we currently do as of February 29, 2020, and there's no end in sight at this point in time, and if you are a frontline employee, and we'll go through that definition here shortly, what that definition entails, and you have been exposed to an infectious or contagious disease, then you may have a compensable workers' compensation claim. Now, even though we look at this bill through the lens of the COVID-19 pandemic, this bill was broadly written to cover any future pandemics or something similar that would require a public health emergency. So theoretically, a governor could issue a public health emergency if the cold has spread too widely, or the flu has spread too widely, or some similar virus has taken a hold, and a similar presumption would be placed. So my point is, this presumption is not just limited to COVID-19, although it is now given the emergency that's been declared, but it can evolve into other emergencies down the road. And as you can see, it's anything that's transmitted through droplets or aerosols or in contact with contaminated surfaces. So this bill is broadly written, and it's going to have wide ramifications as we go forward in the future, and we address future pandemics and related issues. So under this law, the threshold is not very high. The employer, the worker, must provide written or other kind of verification of contraction of the disease. This could be in the form of a note or a letter from their medical provider. The problem is the department is supposed to promulgate rules of verification, and they really haven't finalized that yet. So for now, I'm advising if you receive a note or some sort of document that is verifiable, it's not just something the worker typed up and handed to you, but it has to be something that is a verification, a lab test result, that sort of thing. Then that is proof enough that they had exposure.
Chris, really quickly, when you say department, we're talking about the Department of Labor and Industries.
Yes, excuse me. I'm just used to just referring to the department, but yes, L&I, the Department of Labor and Industries. Thank you, Kelly. So even though it's presumed that the COVID or whatever the public emergency is in relationship to that disease that's work related, you do have the opportunity as the employer, the school district, the trust, to rebut that evidence. We've done this already successfully, but it's not easy. So One of the things that we can try to prove is the exposure occurred from other employment. So we had one situation within the trust where a worker was traveling out of state for many weeks and was in family reunions and those sort of situations, and other people had COVID during that period of time. So that's something that you can try to establish. You can also establish that the exposure occurred from non-employment activities. Given the fact that many employees or workers are working remotely, another thing that you can try to establish is that the employee was working from home for a period of time immediately prior to the incapacity. That period of time, generally under the scientific principles that we're seeing with COVID-19, is a 10 to 14 day period of time is the exposure to symptom period. The other thing that we could try to prove that the employee was on leave for a period of time, so otherwise just wasn't working, was off work immediately prior to being incapacitated from the disease. These four potential rebuttals are very difficult to prove, especially if the employee is not forthcoming in their non-work activities. So I would just advise it's important that if you hear things about where someone may have been at, whether it was on a weekend or a vacation or something like that, that you pass that on to the trust so that we can investigate these potential other ways of being exposed to the virus or the disease. The law also affords time loss benefits for those workers who were exposed. These are the three scenarios where time loss benefits will begin. The first, whichever is the earliest of these three, is when time loss benefits begin, when they missed work, or when they were quarantined, or they received a positive test. However, if the worker receiving benefits through some state or federal paid leave program, then time loss benefits are not going to be paid during that period of time, but could commence once those other state or federal leave benefits have expired. So going to the definition of frontline workers, as you can anticipate, the legislature was pretty broad and inclusive. And here's the list of all the various employees that you work with. So from my perspective, it pretty much covers anyone in the educational services area in the state of Washington: teachers, paraeducators, principals, librarians, bus drivers, support staff, even school district contractors. I put a very important caveat here that these are workers that are required to be physically present in the school, in a transportation vehicle necessary for school, or in the home of a student. Again, going back to the earlier slide, if you have someone who is working remotely at home, this could fall under a different scenario, because the law specifically requires that you must be physically present at the school in a vehicle or at a home teaching a student. So if you do have someone who is working remotely, we may need to investigate that further. They may be in the course of their employment while they're on their computer or otherwise, but this law may not afford them a presumption as it would someone who's working in the school physically. All right, under this law, you have a duty to report outbreaks that come into your facilities. The first requirement, and this would, I would imagine, apply to most everyone that's listening to this, you must have more than 50 employees at a particular workplace or work site. And if you have 10 or more of those employees that tested positive, this duty kicks in. The duty to report kicks in 24 hours after confirming the test results, not after everyone was emailing, maybe there was an outbreak, but 24 hours after confirming test results. And this duty ends when the public emergency ends. So again, I don't see any end in sight where Jay Inslee is going to declare the public emergency is over. I anticipate that we're going to be in the public emergency status into at least the springtime period. Hopefully it will end by summer like it did this past summer, but we never know. But that duty is very limited in time. The public emergency order must be in place. Now, not only do you have a duty to report to others, but you have a duty to report to your employees if these outbreaks occur. Look at positive laboratory tests, look at positive diagnoses of the disease, look to see whether someone has been ordered to isolate due to exposure, or look to situations where someone has been determined to have passed away, as a local health department has indicated the cause was COVID. Just because someone told you that their relative or someone passed away and they think it was due to COVID, it has to be, the trigger is whether the local health department declared the death due to COVID. In those situations, you are required to report to employees in the work site. So here's the duty that is required. Provide written notice to all employees and employers of subcontracted employees. They must have been just the people on the same work site as the qualified individual. So the individual that got the disease, tested positive, or there was a death related to that disease. The way you communicate this is up to you, but make sure that you communicate it to the employees that are impacted by the potential exposure in a way that's similar to how you communicate with them. Otherwise, you can do it through emails, text, or personal service. The key thing here is that you have to be able to provide notice to these employees of potential exposure in the workplace. The law also requires that the communication be in English and other languages understood by a majority of the employees. I would imagine in most situations that other language would be Spanish, but you may be in a certain area where there's more than just the Spanish language that you have to require, that the communication is required to be communicated in. Let's see. As you are talking about these situations at the school district level, make sure you keep privacy at the forefront. You should not disclose the employee name or any personal identifying information that could potentially lead to the identification of that individual that tested positive or passed away due to COVID. If you do not keep that information private, then there are certain penalties as well as lawsuits that could arise from the violation of that individual's privacy. The law also states that an employee is not required to disclose to you their actual medical condition or diagnosis. There's a very fine line between I can get the test results from you, but you cannot require the employee to tell you the actual medical condition or diagnosis as you talk to them about what is going on. Now, if this is a workers' compensation claim, we are going to get that information anyways, because if they complete an SIF2 or incident report or provider's initial report is completed, we as the trust and the attorneys representing the trust are going to get that information. But so trust that we'll get that information at the school level. Don't ask for it. The only thing you can ask for is a positive test result. The law also afforded some protections. The state legislature was seeing situations where certain employees were potentially being discriminated against because of fear of being exposed to COVID-19 or other viruses. And so this new law put some specific discrimination protections in place for what they deem to be high-risk employees. And we'll talk about that definition here in a second. But if these high-risk employees seek accommodation to protect them from the risk of exposure, we should not discharge, replace, or discriminate against them otherwise. If you do, then the law will provide a penalty for you. If you cannot accommodate them, they are to use all available leave, paid or unpaid, until the pandemic is over. And that is going to be a very, as Kelly alluded to early on, we're seeing a number of retirements this year. And if they're not retiring, they could be asking for other accommodations. So we have to be very careful how we sensitively treat these situations. So the law defines high-risk employees as those who are at a certain age. They don't specify the age, but we know under federal law and state law, if you're looking at the the age of discrimination laws, we're looking at age of 40, at least the age of 40, if not older. So that could be someone who's in a high risk, or they have an underlying health condition causing a high risk of severe illness. So that it's not just everyone, it's those very narrow demographics that are considered to be at high risk. And not just that demographic, but the medical provider has to be making a recommendation that the worker be removed from the workforce because of that high risk. So in other words, it's not sufficient enough for the employee to come to you and say, oh, because of my age, I feel like I shouldn't be coming to work, I need to stay at home. The medical provider needs to support that request and explain why that age will lead to the risk of a severe illness. You do have the ability under ADA to seek clarification if you do not believe that that medical provider recommendation provides sufficient justification. As we wrap up here, I wanted to just include, if you have questions, here's some resources. I'll share this PowerPoint presentation with Kelly and she can disseminate to those who are asking for additional information. But these are some key links that I would guide you to if you have any questions about the new COVID-19 rules and regulations and how you navigate these waters. There's a lot of frequent questions and answers that are on these websites and some summaries of what we discussed. We don't have a lot of time in this 45 minute time period that we have this morning to cover all the issues, but here's some links that you can go to that are very beneficial to you. And I'll share this PowerPoint again with Kelly and she can give it to you if needed. So with that, I think I'm ending a little bit early to allow for some questions here. Do we have any?
Chris, I have a question.
Sure.
So let's say an employee comes to work and announces that they have been exposed to COVID. What do you do with that? Or maybe they say, I have COVID. But I guess there's a lot of confusion about when our employers are supposed to direct that individual to the workers' comp trust. So what are your thoughts?
So that's a very good question. Even though L&I, or the Department of Labor and Industries, has sent communications out to employers in the state of Washington, encouraging them to educate their employees about this new law. The law itself does not require you to provide the education. The law itself does not require you to tell the worker to file a workers' compensation claim when they report to you that they may have COVID-19 or may need a quarantine. So that's important that we look at what does the law require. And I went through all those things about what the law does require you to do. As this question has come up, I liken it to if someone came to you on Monday morning and says, my back hurts, does that require you to then say, well, let's fill out a workers' compensation claim and make sure that's taken care of? It doesn't require you to do that. Similarly, if someone comes to you and says, I need a quarantine for COVID-19 or I've tested positive for COVID-19, the law does not require that you then give them a workers' compensation form to complete out and submit to the trust for further processing. All the law does is provide a presumption that if they do file a claim, that COVID-19 or whatever the infection is going to be under the emergency order, that is presumed work-related, but then we work through that process to determine whether it is or it's not. That the law does not require you to automatically hand to them the SIF-2 when they tell you they need a quarantine or they have a positive test result. Now, I leave it up to the school districts and their own, internal policies on how they want to handle that, but the law does not require you to hand them SIF-2 when they tell you that they may have been exposed or they have a positive test.
Well,
Does that answer your question, Kelly?
It does. It adds some clarity because we've had questions already related to this where in one situation, an employee came to work on a Monday and said, oh, gee, I was exposed to COVID over the weekend. All right, well, they volunteered that information. But what if they had come to work on a Monday and just shortened that sentence and said, I might have COVID. Well, in that situation, we could have wrongfully or navigated them over to the trust to file a claim when really they were exposed to it over the weekend when they were not at work. So I think it's kind of a tap dance. You know, there's a thing in workers' comp that's called claim suppression. And so we don't ever want to be accused of suppressing claims. What we do want to do is to be thoughtful about how we navigate this new foreign and tricky to navigate situation. And so we kind of need to work through some scenarios about that. And I like your analysis. You know, if somebody came to you and said, hey, I hurt my back, they didn't say I hurt my back at work. They just said I hurt my back. Well, is it your responsibility to draw out of them? Is that a violation of privacy? I mean, at what point do we say, okay, what do you need from me?
Right.
Anyway.
Yeah, I think you make a good point. We never want to engage in claim suppression. So if they say, you know, I have COVID-19 and I believe I was exposed at work, then that's a different scenario. I think that's a different conversation that you need to have with them. You need to sit down with them. Why do you believe you're exposed at work? Under the law, again, you have a duty if there's an outbreak of 10 positive, you know, employees or more to report it. So in that situation, if one of those 10 employees is within that outbreak, there could be a very good situation as you're reporting that to the authorities that, yeah, you probably know that you have a situation on your hands and that was work related. Then you would want to investigate it and go down that route that you're talking about. But if it's an isolated incident, then you're not obligated to start the workers' comp process, if that makes sense. But if there's an outbreak and you know that, you know, multiple students and multiple teachers were in a certain location and they're exposed, they tested positive, they're having symptoms, then you may have an obligation at that point in time, I would believe, to start the workers' comp process. All right. Any further questions?
I'm not seeing anything in the chat. Thanks so much, Chris. This was great information, and I will send out both PowerPoints to the group after the meeting.
Thank you, Chris.
All right, thank you. You guys have a wonderful day. Enjoy the rest of your meeting.
Thank you. I'm going to go ahead and stop the recording here for a second. Dawn, you're up next if you want to get ready.